Hello and welcome to the second coffee break briefing of 2026. Today's topic is limited liability partnerships and specifically what's different about them. I've got quite a lot of ground to cover this morning, so I'm going to go straight into the presentation. There will be some dates for your diary at the end of all of this, so have a pen and paper ready for that, please. So today's topics, what I'm going to be talking about is I'm going to start by looking at the history of LLPs and why we have them at all. Then I'll be looking at what an LLP is, where I'll be mainly focusing on how the outside world perceives an LLP. Then I'll look at the constitution of LLPs, look at them from the inside, how they're administered, how they're managed. And then the final topic I will be looking at are the insolvency procedures that apply to an LLP, what sort of circumstances you might encounter them. So to start with looking at the history of LLPs, it's actually the 25th anniversary of limited liability partnerships on the 6th of April this year. They're a relatively recent innovation in terms of the ways of doing business. Before 2001, the options were mainly limited companies, then governed by the Companies Act 1985, but still with the familiar forms of private limited companies and public limited companies as being the main types of company that you would encounter. And the other popular way of doing business was also a partnership governed by the Partnership Act of 1890, which is a piece of legislation that is still in force today. There were then, there still are, as a third option, there are limited partnerships, which are closer in form to partnerships under the Partnership Act, but which are different from limited liability partnerships. I'm going to be talking about limited liability partnerships today, not limited partnerships, so I won't say any more about those. So 25 years ago, what happened to give us limited liability partnerships? Well, it was actually a recession in the United States, in Texas in particular, and there were a lot of bank failures. One of the knock-on effects of the bank failures in Texas was that a lot of law firms also failed, and a lot of law firm partners became bankrupt. And so Texas introduced this new type of concept, a limited liability partnership, as a way to allow partners to protect their own personal estates from business risk when they were in practice. It became a popular way for partnerships to do business, and other states in the United States quickly followed suit. And that led to, to it becoming a recognized way of doing business. There was lobbying in the UK from the big four accountancy firms, among others, to introduce limited liability partnerships on a similar type of model here. And within 18 months of the first LLPs being available, all of the big four had converted themselves into LLPs. LLPs remain popular with professional service firms. That's where you're most likely to encounter them. But of course, the regulatory framework has changed over the years. And so we're increasingly seeing professional service firms also setting themselves up as limited liability companies as an alternative. So that's the history of LLPs. Let's now have a look at what an LLP is, and how the outside world treats it. The way I always look at an LLP, which I find most useful, is to think of it as being a partnership within a tough corporate shell, and it's that corporate shell that the outside world will encounter most of the time when dealing with an LLP. So key thing to remember here is that unlike a traditional partnership, an LLP is a body corporate, it's a corporation, it's a type of company in effect. It has legal personality and its members have legal liability in the same way that members of any other limited company have limited liability. So that means when you're looking at how an LLP owns property, it does so as a company. When it makes contracts, it does so as a company. When it's being sued or suing through the courts, it does so as a company. It's only in its dealings with HMRC in terms of its tax affairs that it behaves as a partnership rather than as a company. So looking at those in turn, for LLPs to own property, they can do so in their own name. If an LLP buys a piece of land, its name will appear at the land registry as the owner of that land. That's different from a partnership. Partnerships as such cannot own property. If a partnership wants to buy a freehold, then individual partners in the partnership will have to buy the piece of land on behalf of the partnership, and the names of those partners who have bought it will then appear as the proprietor at the land registry. They will be holding that land on trust for all of the partners in the partnership. But the partnership itself cannot own land, an LLP can. Similarly, when making contracts, as a body corporate, an LLP can enter into contracts in very much the same way that a company can. An LLP doesn't have directors, it has members, so one or more of its members will act as its agent to make the contract on behalf of the LLP. And just as a director signing a contract on behalf of a company is not personally liable on that contract, that's because the director is signing it as agent for the company. In exactly the same way, a member of an LLP making a contract on behalf of an LLP is making it as agent for the LLP. The LLP is contractually liable. The member is only agent for the LLP and is not contractually liable. That's different from a partnership. In a traditional partnership, when a partner makes a contract for the partnership, they're making the contract for themselves as a partner and on behalf of all of the partners, who are then together collectively, jointly and severally responsible for performing the obligations of the partnership under that contract. So partners in a traditional partnership do not have limited liability. They are personally liable. Members of an LLP do have limited liability, and when they make contracts, they are protected because they do so as agent for the LLP. Similarly, an LLP as a body corporate can sue and be sued in the courts. Its name will appear on the court documents as the party to the litigation. When a traditional partnership is sued, its name, the firm name, can appear on the court documents, but if that happens, then that firm name is essentially just the collective name for all of the partners in the partnership. And it's in reality, when the partnership is being sued, it's all of the partners in the partnership that are being sued. That's not the case with an LLP. When an LLP is being sued, it is only the LLP as a corporate body that is being sued. Its own individual members have the benefit of limited liability. They are not being sued when the LLP is being sued. It's when we look at tax that an LLP becomes much more like a partnership again. Essentially, LLPs are taxed in pretty much the same way that partnerships are. So LLPs don't pay corporation tax. LLPs don't pay capital gains tax on their gains. Instead, those profits, those capital gains, are divided among the partners and appear on their individual tax returns at the end of the tax year, and those individual partners will pay the tax attributable to their share of the profits, their share of the capital gain made by the LLP. So that's different from a company, where a company will pay corporation tax on its own profits and its own capital gains. So that's what an LLP is. It is a partnership inside a corporate shell. As far as the outside world is concerned, an LLP is another type of company. Let's now look at the Constitution. Let's look at what's happening inside that shell and how the members of the LLP interact with each other. Now here, an LLP is essentially a partnership. The members of an LLP are very much like partners in a traditional partnership. And the constitution of an LLP can be incredibly informal. There are no model articles. When a limited company is formed, it has to register its constitutional documents at Companies House for the world to see. And there are very good model articles that Companies House make available. And most companies these days are incorporated just using one of the sets of model articles as their constitution. There's nothing similar for an LLP. And like a partnership, an LLP need have no more than just a very informal oral agreement between its members. They don't have to have any written rule book at all. Members are like partners in a partnership in another way. They're both owners, like shareholders in a company, and also managers, like directors in a company. And every member of an LLP is both an owner and a manager, in the same way that partners in a partnership are both owners and managers. And you don't have the Companies Act division of resolutions into ordinary resolutions and special resolutions and board meetings and shareholder meetings and shareholder resolutions and board resolutions. You don't have any of those distinctions. You just have members' meetings and members' resolutions, and those can be about constitutional issues like whether to admit a new member into the LLP, whether to change the rules of the LLP, or they can be administrative stuff about what the office opening hours should be over Christmas and where the desks are going to be moved to in the latest office layout. Or the partners meeting can range the whole gamut of issues from those. But essentially, you've got the same body of people. The members of the LLP have the responsibility for making all of those decisions, from the most trivial to the most significant. There's not that separation of powers that you get with a company. And I've said there are no model articles for LLPs. What there are is some very, very abbreviated default rules in Rules 7 and 8 of the LLP regulations. And so if you do encounter an LLP that doesn't have a rule book, then these default rules will apply. And the first of these is equality amongst members. Profits are shared equally unless the members agree otherwise. But a salary cannot be paid to a member of an LLP. And that's illustrative of another important issue as well, which is that a member of an LLP cannot be an employee, and an employee of an LLP cannot be a member. They are mutually exclusive. That's different from a company where you can have the same person can be an officer, a director, they can be an owner, they can be a shareholder, and they can also be employed by the company and have a service contract. You don't get that with LLPs. The default position is that all members are managers. And unlike a company where the basic idea of a shareholding is that a share is a transferable right, memberships of an LLP cannot be transferred. They can't be bought and sold. And the default position is that it takes a unanimous decision of the membership to admit a new member into the LLP. When it comes to making decisions of the LLP, then it's only a simple majority of members in most cases to make most decisions. But the big decisions that change the nature of the business, and these probably include decisions to appoint an administrator or to wind up the LLP, those big decisions have to be unanimous. Now, where the dividing line is between the decisions that take only a majority and the decisions where the members have to act unanimously, is where that dividing line is not at all clear from the default rules in the legislation, which is another reason why many LLPs do have quite detailed written rules that they themselves have adopted. Members have an indemnity from the LLP. Not going to say much about that now. Members owe the LLP's duties of honesty and good faith. These are very, very succinctly drafted in the LLP regulations. I'll say more about these a bit later on. And members don't have the right to vote a member out. They can't vote somebody out as a basic right. So the rule book of the LLP is going to be very important for you to check and to review if you're going to be advising the LLP or taking any sort of formal appointment over the LLP. Unlike the Articles of Association of a company, LLP rulebooks are not registered at Companies House. They're private documents, not public documents. They are a contract between the members, and there's no particular formality about how the members might set up the rules between them. So they can do so very informally, and in many cases they can change the rules very informally, and you can't always assume that they've kept a good record of having changed the rules. So if you're going to be advising the members of an LLP, a couple of points here for your checklist, the things you should be looking for. Really important to get hold of a copy of the rule book of the LLP, so you know what the internal constitutional arrangements are. And as a matter of best practice, you should get all members to certify that the rule book that you have got is up to date. That's the correct one. That's the one that they're working from, because it's quite possible that they may have made informal, undocumented changes to the rules over time. So you need to have that assurance that the version of the rulebook that you've got is one that you can rely on. You do sometimes find a nasty trap for members of LLPs hidden in their rulebook. And this is because historically many LLP members' agreements have been based on partnership agreement templates. It makes sense. When LLPs were first introduced 25 years ago, they were very much based upon partnerships in terms of the internal management. So a partnership deed was a sensible place to start for writing the constitutional documents of an LLP. Partnership agreements usually say how partners are to share losses. So if the partnership, we're talking about an old-fashioned partnership here, not an LLP. So if a partnership makes a loss in any particular year, then that loss is typically divided between the partners in the same proportions that they share profits, and is then charged to each partner's account with the partnership. I've sometimes seen LLP agreements have a clause like that in them. Now they shouldn't, and the reason is because LLP members have got limited liability under the primary legislation. LLP members are not responsible for the losses of the LLP. If the LLP goes bust, the LLP members are not responsible for putting back the profits, sorry, the losses that the LLP has incurred. But if you have a clause like this in the LLP members agreement that says that the LLP members will share any losses in the same proportion as they share profits, that is actually making the LLP members personally responsible for the losses of the LLP. And it means that if you are the liquidator of an LLP with a clause like that in its membership agreement, you have then got a claim against the members for them to replace the losses that the LLP has made and essentially restore the balance sheet of the LLP to neutrality in the liquidation. That's quite an unpleasant clause for LLP members to find that they have got in their membership agreement. It's one to watch out for when looking at liquidation or other insolvency of an LLP. So that's about the constitution, the inside workings of an LLP. Let's go on now to look at the bit that you've all been waiting for, which is which insolvency procedures apply to an LLP. And remember, an LLP is essentially, it's another type of company. I'm sure at some point a future iteration of the Companies Act will wrap up the Limited Liability Partnership Act as part of the Companies Act, and we'll just see an LLP being dealt with within the Companies Act as another company. Not there yet, but essentially an LLP is another type of company. So all of the corporate insolvency procedures are there, including the 3 types of liquidation, and an MVL Section 110 scheme can be useful if you've got an LLP that wants to incorporate itself as a limited company. It can be a tax efficient way of doing so. You've got administrations, you've got CVAs, although of course they're called LLP VAs rather than CVAs when you're looking at an LLP. And you've got some of the less common types of insolvency procedure there as well. So it's basically the full range of corporate insolvency procedures. Now let's look at what's different with these procedures if you're dealing with an LLP. The first one is passing a special resolution to wind up an LLP. Well, you don't pass a special resolution to wind up an LLP. You instead have to have the members determine that the LLP is to be wound up. How they determine that is going to be in accordance with the constitution of that particular LLP. So if it has a rule book, you need to check what the rule book says, what the procedure is, what the majority should be, and follow the rule book. If you don't have a rule book, then you're going to be looking at the default position, and that really doesn't give you very much guidance at all, except that there you should be going for unanimity between the members to pass the resolution to wind up the LLP. And the same would go for a resolution to put an LLP into administration. That unless it's very clear from the rule book that there's something else, you should be looking for unanimity among the members to do that. Now, with the recent changes that we've got to Companies House, which apply to members of LLPs in very much the same way that they apply to directors of companies, we should now be able to treat the list of members at Companies House as definitive. They should be registered at Companies House if they are a member. Now, there's going to be a problem with unverified members, because just as unverified directors, those who've not had their ID checked by Companies House, unverified directors cannot act as directors of their company. In exactly the same way, an unverified member of an LLP cannot act as a member of an LLP. So suppose you've got this situation. You're looking at putting an LLP into liquidation. It has 8 members, but 2 of those members have not been verified at Companies House, so they cannot act as members. Constitutionally, you need unanimity to put the LLP into liquidation. You need all 8 of the members to determine that the LLP should be wound up, but 2 of them cannot act, so they cannot be part of the process to determine that the LLP be wound up. What do you do in a situation like that? I think what I might suggest is that you get the 6 members who are entitled to act as members to pass the resolution, and you get the other 2 to sign a letter saying, we are members of the LLP, we cannot currently act as members because we are still having our verification process by Companies House. But without acting as a member, we wish to confirm that if we were able to act as a member, we would also be voting to pass the resolution to wind up the LLP. And I think you'd have to do something like that. It might be possible for those 2 members to stand down as members, but they might be giving up important rights for themselves by doing that. So they may be reluctant to do that. The other thing that you might get with an LLP is members in name only. Just as with a company, you can get people whose job title is to be a director without holding statutory office as a director. You can get people who are called partners or members of an LLP who are not actually statutory members and who should not be treated as voting on a resolution of this sort. In an MVL for an LLP, the signatories to the declaration of solvency should be a majority of the designated members. Now, this is the first time I've mentioned designated members. Designated members, every LLP has to have at least 2 designated members. It's possible for all members to be designated members, but they don't necessarily have to be, just as long as there are 2. And these 2 designated members are people who are a bit more like being directors than members in some ways. They have particular responsibility for making sure that filings are done on behalf of the LLP. So it's a majority of the designated members who will sign a declaration of solvency. So suppose you've got this LLP with 8 members. If you can identify the 2 designated members and you're sure who they are, it will be just those 2 designated members who signed the declaration of solvency. If you don't know who the designated members are, because there's confusion about this, then the safest thing to do would be to get all members to sign the declaration of solvency, because that way you will capture those who are designated members as well as any who aren't. So that's probably the best way of doing it in that situation. Just as with a company, you can get overdrawn directors' loan accounts. With an LLP, you can get overdrawn accounts of the members. And this is a result of the way that profits are divided up amongst the members of an LLP. What will happen is normally that the members will be drawing from the LLP every month for their own personal living expenses. And then when the accounts of the LLP are agreed, their share of the profits will be agreed, and they will be effectively added to their current account. So if at any one time a member has drawn more from their current account than has been added to it in profits, they will have an overdrawn current account, and it may be a debt that can be called in at that point. Some LLPs will run separate current accounts and capital accounts. Others may have separate. Others may have a single account for both capital and current. And on a liquidation, set-off may apply to effectively collapse both the capital account and the current account into one account. So it may not be that straightforward as to identify whether or not there is actually a debt due from a particular member or not. And remember that a well-written, a properly written LLP agreement won't deduct losses from members' current accounts. So if an LLP makes a trading loss in any particular year, a properly written members' agreement should not see that loss being divided up amongst the members and deducted from their individual current accounts. That should not be happening. Misfeasance claims against members. There's a can of worms. You've got the summary procedure in section 212 of the Insolvency Act. That does apply, but remember that is only a court procedure that you get through section 212. It doesn't actually define misfeasance as being a claim that you can make either against company directors or against members of an LLP. You actually have to show that there has been a breach of a particular duty by a particular member to bring a misfeasance claim, and if you can do that, you can then use the section 212 procedure. Where it gets a bit more complicated is that the directors' statutory duties in the Companies Act do not apply to the members of an LLP. So you can't base misfeasance on a breach of any of those directors' duties. I already mentioned that the LLP regulations do include a very, very concise and not very detailed obligation of good faith and honesty on the members of an LLP. You might be able to use that as the basis for a misfeasance claim. If there is a members agreement and you can show that there is breach of its terms by the members, that can be a misfeasance claim as well as being a breach of contract claim. And partnership law has evolved fiduciary obligations on partners in the same way that company law did with directors of companies. Many of those fiduciary obligations have effectively been codified in the Partnership Act and therefore won't apply in their codified form, because the Partnership Act applies only to partnerships and not to LLPs. But it may be possible to argue that the sort of uncodified version of the rule should apply in some way to the members of an LLP. That's going to be quite a difficult one to argue, but it's possible. Section 214, wrongful trading, applies to members of an LLP as it does to company directors. And we've got this recent development by the courts of this idea of misfeasant trading, which is sort of wrongful trading where you're arguing it on the basis of breach of directors' duties. That's going to be difficult to run in the context of an LLP, simply because those statutory directors' duties do not apply to an LLP. In an LLP, you've got an entirely new basis for bringing claims against the members of an LLP, and that is Section 214A of the Insolvency Act, which applies only to members of an LLP. And essentially, this allows you to look back over the last 2 years before the liquidation and look at drawings or other property that the members have taken from the LLP in that time. And if you can show that the member knew that the LLP was cash flow insolvent at the time when the money was taken out, then you're able to ask the courts to order that the member pays it back. Section 214A is very rarely used, and just as Section 214 wrongful trading claims are notoriously difficult to bring, so too are Section 214A claims. Preferences, transactions at an undervalue, and fraudulent trading, all very much the same as they are for companies. Tax issue is, of course, interesting and different. In a liquidation, the liquidation destroys tax transparency. So effectively, when an LLP goes into liquidation, it stops being a partnership for tax purposes and it becomes another corporation for tax purposes. And the consequence of that means that if, as a liquidator, you're realizing assets and you're generating a trading profit or making any capital gains, then those trading profits, those capital gains, do not appear on the individual tax returns of the members of the LLP. Administration, of course, is different. Administration does not destroy tax transparency. So when an LLP goes into administration, as far as HMRC are concerned, they're likely to see the partnership still continuing within the LLP, with the consequence that there is a risk that if there is a trading profit in an administration, if you realize assets in an administration to make any chargeable gains, the tax bill for those may fall on the members of the LLP rather than being an expense of the administration. And I think the takeaway from that is to make sure that you tell the members of the LLP to take advice on their own personal tax risk if you're working with them in the run-up to the LLP going into administration. So that's a very quick run through of the corporate insolvency procedures that apply to an LLP. So that brings me to the end of this morning topics. My apologies, I've gone, I think, 4 minutes over the scheduled 30, so my apologies for that. Now is the time for questions, and I see that I've got 3 questions. Again, I apologize for not stopping to look at those during the presentation, but let's just see what we've got now. Let's see. Mark Hopkins has asked, he said, a question where I say that trading losses should not be applied to members' current accounts. And it's saying, presumably when losses are incurred, there is no trading profit to cover a member's drawings throughout the year, in which case, presumably the drawings are repayable. And yes, that's likely to be the case. Now, there may be this issue of set off of the current account and the capital account, so the drawings may be regarded as drawings of the member's capital rather than creating a debt. But if they've but there are circumstances when that set off won't apply, and if they have drawn more than their current account and their capital account, then yes, the drawings would be repayable as effectively a loan. Again, it may be possible for the members' agreement to deal with that situation and to say that in a case like that, even though there are no profits, nevertheless the payments to the member are to be regarded as legitimate. I'm not sure how that would work necessarily, but the basic principle is yes. If they haven't got profits because they've made losses and those losses are being paid into a suspense account, then their account is likely to be overdrawn. Kevin Parrish has asked whether the cannot act restriction for unverified members applies only after their verification has fallen due, and yes, it does. I think members and directors are given something like 14 days to verify themselves when it first falls due, and if they have not done so within 14 days, then they are no longer entitled to act. So yes, it's only when their verification has fallen due if they're unverified. Companies House are now marking directors who are unverified as such, and I'm sure they'll be doing the same for unverified members. So if they appear at Companies House as unverified, that's going to be a problem. Question here from Kim Richards. If an LLP finds itself with only one member, can a resolution still be determined? That's a good question. And I have to confess, I didn't do the research in preparing this. I've got quite a lot else to cover, so I haven't done the research into what happens with a single member LLP, but I'll have a look and I'll circulate the answer to that with the notes about next month's coffee break briefing. So Kim, thank you very much. Good question, and sorry I haven't got the answer to it. So those are all the questions I've got. So last thing now is to give you some dates for your diary. If you're local, then we've got the R3 regional meeting at the Empress of Blandings at Copythorne on the edge of the New Forest this Thursday evening. There's 3 presentations there. I'm going to be giving one on bankrupt shareholders. It's a pub, it's in the New Forest. They have beer, there's a chance to have a bite of food afterwards. If you can come along to it, please do so. It'd be great to see you there. I'll be at the R3 Personal Insolvency Forum in London on the 5th of March. I went to it last year and I thought it was a really good, really useful event. Next coffee break briefing will be on the 9th of March, and I'm planning to give a very much an overview of the National Security and Investment Act. And this is the situation where you can find that the requirements of national security mean that you're unable to sell a business to the buyer that you want to sell it to until you have clearance for doing so. And of course, such clearance can be refused. Thursday, the 18th of March is the date for the R3 Southern Forum, and that's in Lincoln's Inn in London. So if you're outside my area, there's a good chance you might be able to come to that. It's got a really good program. It's booking fast. Go straight onto the R3 website immediately after you log off from this to book on both the regional meeting this Thursday and also the Southern Forum on the 18th of March. Then we've got first SESC is in first SESCA insolvency seminar at Denbies is on Thursday, the 21st of May. Very important date for your diary after that is Friday, the 5th of June, which is Fretton's 4th annual insolvency conference, to be held at a venue in the New Forest. It should be a really good day, so please keep that day free, and I'll let you know when bookings become available for that. And the last two dates are the annual conference for SESCA and the second SESCA insolvency seminar at Denbies. So I hope to see you at least one of those events at some point during the year. And with that, I can see there's no further questions. I've said everything I intended to say this morning. Thank you very much indeed. Hope you've enjoyed this morning, and I hope to see you either on Thursday or 5th of March, or possibly the 9th of March, or some other time later this week. Thank you very much indeed, and goodbye.